I'm back. Going to do a real short video here, keep it short and clear and concise. This video is in relation to the previous two on the notice of rescission thing. And I want to start off here with information at our blog. The blog is www.restorethekingdomofgod.blogspot.com. The link to our blog is in the description area under this video here. So when you get to the blog, the first thing you'll see there, it says, own nothing, control everything. The holder of a birth certificate enjoys the presumption of a perfected lien, evidence of the holder's lien against the straw man. It exists whether we claim it or not. Now this blurb here is about what my friend did in the traffic court when he used the birth certificate. A friend of mine was involved in a traffic court, a minor offense. He tried something based on information we had at that time. He was able to settle the matter with his birth certificate. The method he used was effective and had the desired effect to settle the matter. It was done. The matter was done that day. So what did he do? Keeping in mind here, birth certificate, notice of rescission, all of that's, you got the evidence here, XY versus HMQ, that the birth certificate is not evidence of the identity of the one presenting it, not evidence of the identity of the bearer. So we walked into the court on that day, traffic court, walked up to the provincial prosecutor, presented as the bearer the birth certificate and said, I present this birth certificate not as evidence of my identity, but of my interest, and I'm here to release my interest for the settlement of any and all charges, and the matter was done. Now, this whole thing takes on a whole new meaning when you know you can prove now, or they can't prove, you can prove the birth certificate is not evidence of your identity, or they can't prove that it is, right? But it's also evidence of your interest. Why is it evidence of your interest? Well, when you're not that, who's the one behind it that's doing the work? Who's the benefactor here? That would be you, the man, woman, right? So once you've isolated or separated yourself from that person named on the birth certificate, that's not evidence of your identity, then you're not that. But you're there and you have the certificate. You're the one doing the work. You're the benefactor. This is why you have an interest, not solely, but this is why you have an interest. So can you see how this fits perfectly with the rescission thing we've talked about? Takes on a whole new meaning now. You know, you can prove the birth certificate is not evidence of your identity, and they cannot prove that it is. Again, he presented it not as evidence of his identity, because that's not what it is, but evidence of his interest, because that's what it is. And he's there to release his interest for the settlement of any and all charges. Now keep this in mind, when you got it on the table that you're not that, where are they going to go? You got a charge here and they're going, okay, well, we can't stick it to him because it's not evidence of identity, but you're there now to help out, help yourself, help them, whatever, get the matter done, get your ass out of there, and, you know, start putting stuff out there that you know what's going on. The birth certificate is not evidence of your identity, it's evidence of your interest. And again, in his case, he was there to release his interest for the settlement of any and all charges, and it was done. A little more to that you want to do these days that we know that he should have done a little bit better than, but the point is, had the desired effect. But my main thing here is to point out that when that birth certificate, you got to establish that the birth certificate is not evidence of your identity, and it's not. That it's evidence of your interest, and it is, and you need to know why. Again, you're the one doing the work, right? You're the man behind the mask, benefactor. Then darn right you have an interest, and you can release that interest for the settlement of any and all charges. And I think that's all I had to say here. Let me take a sip of my coffee here and I'll let you know. One more little thing. So once you've done the, in relation to what my friend did in court verbally, once you've done the notice of rescission thing and you've got that evidence now that it's agreed that the birth certificate's not evidence of your identity, I mean, it's all just rock solid. You slap that down in front of them, whoever, wherever, whenever, that it's not evidence of your identity and it's not, then that's the no-brainer part. Evidence of your interest there to release my interest for the settlement of any and all charges. So the notice of rescission thing is a very powerful tool in that regard, and I've discussed that briefly in the previous two videos. And it doesn't matter what country you're at, it's the same for everybody. If they're issuing birth certificates, this information applies. So the notice of rescission, the final, after the procedure's done, bang, like I said, and I think in one of the videos, you can do whatever you want with it after you've got the final agreement with the Attorney General there. So very powerful document once that's in place. And like I said, use it wherever you need to use it, whenever you need to use it, any way you need to use it. We'll be talking about these things in our Zoom meetings, different ideas for people. Thank you much. God bless. Love you. Lighter God never fails. Till next time, take care. And I should have said, the notice of rescission is really just a formality. So it's giving them an opportunity to dispute. There's nothing for them to dispute, but at least you've done that, given them the opportunity. That's the idea behind that. And that's what I mean by agreement. So you give them a certain amount of time, and then they can't rebut it. The facts, it's the facts, the evidence is their own evidence, right, or the lack thereof. And so it is what it is at that point. So, and yeah, you can slap it down wherever, mail it off wherever, whoever, whatever you got to do with it after the procedure's been finished. Love you. God bless. Later. God never fails. Ciao for now. Morning, people. I'm back. I was uploading a video here, and I received an email this morning that's very relevant to the rescission thing we've been talking about, the rules of equity that I've been talking about, and with respect to the concealment of the material facts and how we can restore our standing before all of this birth certificate stuff happens, so we can get back to being men and women. Anyhow, I want to read this to you, and then I'll add this to the video and re-upload it. Hi, Adam. I hope this finds you well. I would like to share this victory of sorts with you, and if you desire, with your students. I have simplified the case as the timeline was very long, drawn out, and a complicated affair. Proof that the laws of equity are alive and well in Australia. Around 18 months ago, a friend of mine had been battling a complicated case with a superannuation insurance company for almost 7 years in regard to an insurance payout. After 5 different case managers over the 7 years, and each one of them contacting my friend stating that her insurance claim was dead in the water, and each one of them telling her that they required her consent to close the claim. The fact that they each parroted the same line, "I need your consent to close the case," said to me that there was in fact a chance that her claim wasn't dead at all. I asked her if she could check out if he could check out the paperwork. I found that after she had a few exchanges with the company, they informed her that the case was dead, so she moved her superannuation sum to another provider. By doing this, it left no funds in her account to pay the insurance premiums. They stated that as she had moved the funds and due to the timeline, she wasn't covered for the event. I sent them a letter using the reasonable man doctrine. That's something we talked about early on in the Reclaiming of Securities, this reasonable man doctrine thing, to say, would a reasonable man have moved the funds from the account at that time had he known that it would have ended the coverage, keeping in mind that they had previously told her that the claim was dead, but was in fact still alive and well. I also stated that she had suffered harm, financial hardship, caused by their stalling, their that the half-truths they told, and that they needed to make good for their wrongs. They replied with a letter stating they needed 40 days to deliberate. I checked the company's constitution and found that the 40-day period is used to liquidate shares and stock. In just under 40 days, and almost 7 years after the initial claim, an offer of $220,000 plus $31,000 in interest was offered. My friend accepted and was paid the same amount within 21 days. I hope this is useful. Kindest regards, Rick. So there you have it. It was brilliant what he did. He used his own head there. But anyhow, like I say, it's confirmation with respect to the exactly what we're talking about here, with the rescission thing, the concealment of material facts. And the rules of equity. So, that's it. That's all I wanted to add to this video here. And God bless. Love you. Take care. And God bless. Later, God never fails. Till next time.